You everyone for your patience. Based on our conference in chambers, I think that there are matters we need to put on the record with respect to the aggravating and mitigating factors. So, Mr. Bradsher, the state has alleged that you held a public office or at the time of the offense or offenses for which you've been found guilty, and that these offenses relate directly to your conduct of the office. And what's your position with respect to that aggravating factor, sir?
Yes, Your Honor. While I do not concede that I committed the offenses, I do respect our jury system and the verdict. And based on the verdict on the offenses they came back guilty on, I do admit that during that time that I held a public elected office at the time of the offense that the jury has returned a verdict on, and that the offense, as the jury found, directly related to the conduct of the office that I held as district attorney. All
right. So based on that admission, let me just ask some questions of you regarding that admission to make sure that you understand your rights with respect to this, and I know you do, given your education and training, but you do understand that with respect to this admission, you do have a right to remain silent, and anything you say can be used against you. Is that correct?
I do, Your Honor.
And what is your education level, sir?
I have a Juris Doctor from Campbell University School of Law.
Are you under the influence of any alcohol, drugs, narcotics, medicines, pills, or any other impairing substance?
I am not.
All right. When was the last time you used or consumed any impairing substance, sir?
June 16th, 2017.
And you understand the nature of the aggravating offense that we've just discussed, do you, sir?
I do.
All right. And you understand any defenses that there might be to that aggravating factor?
I do.
All right. And you understand that you have a right to contest that aggravating factor and have that issue submitted to a jury?
I do.
And you understand that at this phase 2 proceeding, you would have a right to confront and cross-examine witnesses against you?
I do.
And you would have the right to have a jury deliberate this aggravating factor issue?
Yes, Your Honor.
All right. And you understand that by your admission of this factor that you were waiving your right to your constitutional rights to a jury proceeding on this aggravating factor?
I do, Your Honor.
All right. And you understand that because you are stipulating the aggravating factor, that may affect your ability to appeal the stipulation of the aggravating factor. I understand you are preserving your right to appeal the underlying offenses and the convictions for that, but that with respect to the aggravating factor, you likely be waiving your right to appeal that.
I do acknowledge that, Your Honor.
And you understand, sir, that with respect to the aggravating factors, it would only apply to the sentencing on felonies, and it, as an aggravating factor, it enhances the potential punishment that you face for these felonies. Theoretically, the jury has returned a verdict of 3 felonies. Each of those are H-class offenses. Were you a level 6 offender, you would face up to 39 months incarceration for each of those 3 felonies as a level 6 offender. I understand from the information that I have that you are in fact a level 1 offender. As a level 1 offender, an aggravating factor could subject you to as much as 19 months incarceration for each of the 3 felonies. Do you understand that, sir?
I do, Your Honor.
All right. And do you personally acknowledge the existence of the aggravating factor that we've just discussed?
I do, Your Honor.
All right. Do you understand that you also have the opportunity to present mitigating factors to the court?
I do, Your Honor.
All right. And do you understand that you can discuss mitigating factors and aggravating factors with me and without my disapproval?
I do, Your Honor.
All right. Okay, very good. I'm going to find that you have knowingly and voluntarily admitted to the existence of an aggravating factor in this case. Let's go ahead and state and hear your position, Mr. Bradsher, on mitigating factors, and we'll get the state's position with respect to any mitigating factors that may exist.
Yes, Your Honor. Would offer a factor in mitigation that December 27th, 1995, I was honorably discharged from the United States Army. I would also, I will find that. That is mitigating factor E14, Your Honor. The other mitigating factor that I would offer is that I am married with 7 children and have a strong support system in the community in which I live, Person County, which is mitigating factor number 18, as well as number 17, that I have supported my family. I would also offer mitigating factor number 16. The defendant has entered and is currently involved in or has successfully completed an alcohol treatment program subsequent to arrest and prior to trial. I am a recovering alcoholic. I did submit to UNC ASAP program for an alcohol assessment and determined that I was an alcoholic. I then proceeded to complete 6 months of treatment, successfully completed that program. I continued with AA after that and have remained alcohol-free for over a year. Recently gained my 1-year medallion from AA. There are other mitigating factors, Your Honor, that are listed in the statute that I could propose. However, those are the ones that I sent by email to Mr. Latour last night, and I think the most relevant. I also will concede that even with my service to the military, addressing my alcohol problem, that and the support of my family and my reputation and support system in my community, that I acknowledge that the aggravating factor weighs heavily in terms of the court's imposition of a sentence. So I don't diminish the aggravating factor that exists, although I contest the charges that I've been found guilty of. But I did want the court to know at least those 4 mitigating factors for your consideration as you impose judgment.
All right, thank you. Mr. Latour, what's the state's position with respect to these mitigating factors, sir?
Your Honor, given the posture of where we are and the presentation of the defendant as to those mitigating factors, the state would stipulate to the existence of those mitigating factors.
All right, very good. All right, that puts us in a position where we can bring the jurors in and go ahead and release them. We'll have a sentencing hearing after that, but since the aggravating factor no longer is contested, we can let the jurors go ahead and go about their business. So, bailiff, if you would bring the jurors in, and they can just leave their materials in there. We'll talk to them briefly and then send them back out that way with you. Yeah. All right, ladies and gentlemen, welcome back, and welcome back to our 3 alternate jurors who've joined us. And appreciate your patience. What's occurred in your absence in the last few minutes, well, let me just explain to the 3 alternate jurors who were just joined us so that they're on the same page as the rest of you. Yesterday, this jury of 12 returned guilty verdicts on 5 of the 7 offenses. Those offenses are obtaining property by false pretenses, aiding and abetting, the obtaining property of false pretenses, the misdemeanor felony obstruction of justice, the felony obstruction of justice, and the misdemeanor failure to discharge duties of office. The state had also alleged with respect to 4 of those 5 offenses an aggravating factor, the aggravating factor being that the defendant held public elected or appointed office at the time of the offenses, and the offenses directly related to the conduct of the office. And so that was the aggravating factor that the state alleged. As I mentioned to you yesterday, an aggravating factor is not a crime in and of itself, but it is a factor that enhances the potential punishment that a person who is convicted of a crime faces. In this matter, Mr. Bradsher has now stipulated the existence of that aggravating factor. He has a right to have that issue determined by a jury, but he has waived that right, and he has stipulated that that factor applies. And so what that means for all of you is this now concludes your duty. You've completed your service as jurors. We want to thank you very much for your careful attention throughout this trial and your patience with us throughout this process. We're certainly grateful for your service to the court. I know on behalf of myself, on behalf of the state, and Mr. Bradsher, we thank you for your service. So your service is concluded. The rules that I've been discussing with you throughout this process no longer apply. You're free to talk about this case with anyone you choose, or you're free not to talk about it. It's completely up to you. I do urge jurors, if they choose to discuss a case publicly, that they respect the privacy of their fellow jurors. It may be that your fellow jurors don't want their personal views shared publicly, so I would ask that you respect that if you care to. That being said, you're free to go. What happens next, in a few moments, we'll conduct a sentencing hearing in this matter. You're free to observe that as members of the public. If you do wish to observe that, I'll ask that you just come in the back door there, just let the bailiff know, and he'll let you go right out that door. You're welcome to observe it, but there is no need for you to stay and observe that. You play no part in it. You've done your job, and we thank you for doing that. Return your badges, get your personal belongings. You can leave all your notes and all those materials there in the jury deliberation room. The clerk will destroy those for you, so you need not worry about those. But again, thank you. You're free to go. Return, and is the state ready to proceed with sentencing at this time?
Yes, Your Honor, the state would pray judgment.
All right. And do you have a prior record worksheet?
I do. I was going to give that to counsel.
All right. Why don't you review that? I'm going to take a few moments, and then we will proceed with sentencing procedure. All right, we're back on the record. Ms. Latour, do you have a prior record worksheet, sir?
I do, if I may approach.
Yes. Thank you, sir. All right, Mr. Bradsher, is it stipulated you have a prior record level 1 based on no prior record points?
Yes, Your Honor.
All right, very good. All right. Let's move forward then with sentencing in this matter. Mr. Latour, I'll hear from the state first.
Your Honor, as we've kind of forecasted, I understand the court's dilemma, or not dilemma, but concern in whatever sentence might be appropriate in this case. I understand it's a difficult case for us all to be a part of. It is not absent, or it does not escape the state the distinction that has to be made between what the possible sentences for the Blitzers, or for Craig Blitzer, and for this defendant are. I would submit to the court that there are some distinctions, as we have raised and pointed out throughout the trial. I will tell the court that in my review of the charges for which the defendant has been convicted, it is likely that the two obtaining properties, something would need to be fashioned as either to consolidate or arrest judgment as to one of those, considering the factual allegations. And so I would ask the court to consider and do that so that it's an appropriate sentence moving on from here. I would submit to the court that an active sentence, at least in some part, is appropriate, given that the defendant's position and the aggravating factor that has been stipulated to, that he held a public office and had a position of trust and granted to him by the people of this state, and that he breached that trust, as the jury has found. I will further say that the reason that I think an active sentence is appropriate in this case comparatively to the Blitzers is that, as the jury has found, the defendant, instead of accepting the responsibility at an early stage, made some efforts to either conceal or compound the issue by the convictions of obstruction of justice. And as an elected official, I think that the public trust would require some sort of an active sentence as it relates to these charges. And other than that, I don't wish to be heard.
All right. Mr. Bradsher, do you wish to be heard, sir?
Your Honor, just simply to say that the court knows I've contested these charges. If I were in fact guilty, I completely agree with everything Mr. Latour said. However, you know that I have contested that and contend I am not guilty. However, I'm a part of a system where I respect each phase of the system. The jury has spoken, and I accept that judgment. The court knows that I will give notice of appeal. but I do not contest any of the priorities the state indicates is important for a sentence in this type of matter. So I simply submit to this court to enter a sentence in your discretion consistent with what you have seen and what you've heard from Mr. Latour and what you've heard from me. Thank you.
Thank you, sir. All right. So, Mr. Bradsher, as Mr. Latour said, this is the court finds itself in a difficult position in this case. It's you are a skilled advocate. You've demonstrated that over the past several weeks. You are a man of intellect, and obviously the evidence, I think, shows that you worked hard throughout your career. You've got a family, a fine family that's been here throughout the time. You've presented the court with some significant mitigating factors. You've been honorably discharged from the United States Army. You have strong support in the community. You have strong family support, and you've completed an alcohol treatment program. The court accepts and finds those mitigating factors. You've also acknowledged that there's an aggravating factor, and that is that you, at the time of these offenses, you held a public office, and the conduct of these offenses relates to that public office. That is a significant aggravating factor. And it brings to mind the saying simply that to those to whom much is given, much is expected. And so for that reason, I do think that an appropriate punishment in this case is warranted. So there's several things that we need to discuss. First of all, with respect to the license that you hold as a lawyer to practice law in the state of North Carolina, given the nature of these offenses, in my inherent authority to act on behalf of the bar with respect to your license, I'm going to order that you be disbarred and that you surrender your license based on the nature of the verdict that the jury has returned. And so I'm going to ask that that take effect immediately. Now, with respect to the offenses in this case, starting with count 2, which is obtaining property by false pretenses, with respect to that matter, I'm going to find that you have a prior record level 1. I'm going to sentence you in the mitigated range and order you serve a sentence of 4-month minimum, 14 months maximum in the custody of the Division of Adult Corrections. That will be an active sentence. I'm going to order that you serve that in light of what I would consider potential security concerns, not that you are security concerned, but based on your position as a district attorney in the state of North Carolina. I'm going to order that all precautions be taken to protect you from harm while you're in the custody of Division of Adult Corrections. What I'm going to order is that you be housed in the custody of the Person County Sheriff, if that at all is possible. I believe that that, in my discretion, would be the optimal place for you to be for your safekeeping. But I'm going to require that you report to begin that active sentence at 9 a.m. You'll need to report to the custody of the Wake County Sheriff's Department. That's on June 25th, 2018, to be processed to serve that active sentence. I'm going to arrest judgment in count 3, which is aiding and abetting the obtaining of property by false pretenses. Actually, I'm going to reverse that. With respect, the active sentence, Madam Clerk, would be with respect to count 3, the aiding and abetting, and I'm going to arrest judgment on count 2, which is the obtaining property by false pretenses. With respect to count 5, which is obstruction of justice, felonious obstruction of justice, I'm going to sentence you in the presumptive range of 6-month minimum, 17 months maximum. That sentence is suspended, and I'm going to place you on 24-month supervised probation, which would commence at the expiration of your active sentence. As a condition of your probationary sentence, I'm going to require that you perform 250 hours of community service over the first 12 months of your probation. I'm going to require that you continue to participate in substance abuse treatment program, and I'm going to require that you pay the costs of court. I'm going to consolidate into that offense the two misdemeanor offenses, which would be the failure to discharge duties of office and the misdemeanor obstruction of justice. Those will be consolidated with count 5 on that matter. I believe that is all.
Your Honor, to those respectfully, I've given notice of appeal, and I understand that my understanding of the law is that the probationary matter would be stayed as a matter of law, however, the active sentence would not.
That's correct, sir.
And I would request, Your Honor, given the voluntary surrender and the court's order with regards to my law license and the period of incarceration, that I be considered for appointment by the appellate defender.
All right. I'll have you complete an affidavit to make sure you qualify for that, but I will appoint the appellate defender to represent you further in all proceedings relating to your appeal, subject to approval of an affidavit relating to that. All right. All right. Anything further, Mr. Latour?
No, Your Honor. Thank you.
Anything further, Mr. Bradsher?
No, Your Honor.
All right. Thank you very much. The court's in recess.